Hello, jurors. My name is Oscar.
And I'm Juliet.
And today we'll be addressing some issues and obstacles that you may encounter throughout your juror experience and how to address them.
For many of you, this might be your first time serving as a jury member, so in this video we will be addressing hypothetical cases and possible scenarios. So without wasting another moment, let's get started. Do not talk to anyone about this case or anyone that has anything to do with this case. This includes members of your family, employers, or friends. Don't read any news stories, articles, or look at any social media posts about this case. And do not express any opinions until all evidence has been presented to you and you've been discharged to deliberate. Thank you.
Man, the defendant looks so guilty though. Like, I'm gonna pull up a video, see if I can find some more information on this person.
The problem with pretrial publicity is the juror is being exposed to material that can be biased and prejudicial that may have nothing to do with the current crime allegations. When jurors are exposed to pretrial publicity, it can impact their ability to remain impartial and make fair and unbiased decisions during the trial, not providing the defendant with a fair trial.
Solutions for pretrial publicity. Ways to avoid pretrial publicity is by making sure you don't get involved with any of the people involved or discuss the case with anyone. One effective way is to temporarily delete any social media applications to avoid any temptations or accidental occurrences from being exposed to pretrial publicity during the trial. Our second issue is inadmissible evidence. In this scenario, we have the state doing a direct examination on the responding officer who apprehended the suspect.
So, officer, can you please explain to me what happened when you apprehended Jamel Stevens? Well, at first I put Jamel in a chokehold, and once I pinned him to the ground, he said that he was the one who committed the murder.
Objection.
Counsel, you may approach. Ladies and gentlemen of the jury, I want you to disregard the recent statement made by the officer.
I heard the cop say the defendant confessed. Like, why are we not discussing that? Like, let's make this easy on us.
I don't think we should be taking into account that information because the judge said not to, but it's hard to let someone walk free apparently if they had confessed to the crime. The more I try to not think about it, the more the confession sticks out to me.
The problem here is the backfire effect is taking place. The backfire effect is when someone tells you not to do something, yet you still do it, with jurors discussing evidence that was marked as inadmissible. Juror 1 is illustrating an example of a reactant's response by deciding to reestablish his freedom by choosing to take into account the confession statement even though it was ruled as inadmissible. Juror 2 shows signs of the ironic process where he knows he shouldn't be thinking about the confession, but he can't get it out of his head.
Solutions regarding problems of admissible evidence. Ways to avoid having issues with inadmissible evidence being presented in trial is to remember that the legal system relies on a fair and impartial deliberation of all the evidence. Avoid having reactive responses and solely base your decision on the evidence that is properly admitted into the trial.
Eyewitness issues. In this scenario, we have the defense doing a cross-examination on a key eyewitness.
Defense, any cross-examinations?
Yes, Your Honor. Is it true that you claim to have seen the defendant yesterday kill someone at night?
Yes, the defendant shot his black gun.
Is it true that you didn't have your glasses on at the time?
True.
It is true that you're farsighted and you can't see relatively far.
Yes.
On direct, you said that you had a clear view of the park outside your apartment window, but you also saw incoming traffic crossing. Is that correct?
Yes, there was some car traffic, but I don't really think that affected the situation.
You saw both individuals wearing beanies?
Yes, I know the person that I saw was black and it looked like the defendant.
And in your voluntary statement, it said that the incident took no longer than 1 to 2 minutes?
Yes.
No further questions, Your Honor. I think the defendant is guilty. The witness sounded super confident when it came to recognizing him and identifying the person holding the weapon. I'm sure that if I were in her shoes, I wouldn't have forgotten that person's face.
I think there were some problems with the eyewitness testimony. She didn't have her glasses on and traffic was ongoing at night. The defendant and the victims were both wearing beanies and I was under the impression that the white lady was biased towards white folk. I think we should consider the other pieces of evidence and see if their testimony actually makes sense.
Eyewitness issues that can present themselves as cross-race identification, which deals with individuals being less accurate at recognizing members of a different race due to possible prejudicial or heuristic bias. Another present factor that could be altering the witness's testimony is the firearm, because the witness might have been more concerned with where the gun was being aimed at than who was holding it. Issues such as having bad eyesight or the environment they were in regarding their arousal level can also be factors that impact a person's ability to perceive what's taken place. Depending solely on eyewitness testimony can be inaccurate and unreliable. Try to consider all the pieces of evidence.
Solutions for eyewitness testimony. Things to consider when listening to eyewitness testimonies is that a person's memory can change over time and is not like a video recorder, such as how the weapon's focus effect is how a firearm can draw a person's attention away and can impair their memory of the event. Consider the cross-race identification, with witnesses being more accurate at identifying members of their own race as opposed to other races. And understanding the confidence levels projected by witnesses is not an excellent indicator of reliability. Lastly, take into account arousal levels, with studies showing that having a very high or very low arousal level can cause inconsistencies in your memory, with a moderate level of arousal being optimal. Be aware of these factors and consider testimonies with other pieces of evidence. In this scenario, for ignoring biases, we have an attractive defendant taking the stand after being charged with tax evasion.
Catch a look at the defendant. She was smoking hot. I don't think she committed tax evasion. She didn't look like she had the brains to do it. If anything, it was the nerdy guy with the glasses that came in. He was walking in like a robot. And he kind of confused me with his big fancy words. I'm sure somebody tried framing her because she didn't probably want to sleep with him.
Yeah, she's also a single mom just like me. I feel like I can relate with her because I barely have any time to keep track of how much I spend at the grocery store, let alone try to cheat on taxes. I don't think her appearance is relevant to the matter or the fact that she might have some similarities with you. We should actually take into account and look at the actual evidence presented in the court. We have images of her spending money on lavish cars, and we also have her tax papers right here and some of her biggest purchases she made. She has also gone on record to say how she knew how to play with the IRS.
The problem here is the juror is basing his decisions on representative heuristics. The juror is judging the likelihood of something by how well it matches a particular prototype. In this case, he thinks the woman is very attractive and she is incapable of committing tax evasion and relies on a person's appearance to decide if they might be credible or not. Jurors might reach an inaccurate conclusion if they rely on bias and experimental thinking by making quick decisions and putting more emphasis on their emotions.
Solutions for avoiding implicit biases. In order to avoid making inaccurate judgments, we recommend jurors to engage in cognitive and rational thinking by thinking through all the evidence and taking your time when deliberating before making any quick decisions. Avoid being persuaded by heuristics or stereotypes such as appearance, education, or certain credentials. Instead, try relying on a more systematic approach by actively engaging to the message strength being presented in court, and avoid certain types of biases or defendant similarities that might cloud your judgment. Now we will go over understanding basic procedural instructions. First is the burden of proof, which it falls on the prosecution. The defendant is always going to be assumed innocent. The defense doesn't have to present any evidence to show that he or she is innocent. A unanimous decision is when a decision is reached and supported by everyone in the group and everyone has reached the same consensus.
Legal thresholds. Beyond reasonable doubt is a really high legal threshold used in criminal cases. Must be almost completely positive, but doesn't have to be absolutely certain. Jurors and attorneys estimate reasonable doubt to be having around 90% certainty. Preponderance of evidence is another legal threshold and mostly used in civil cases. Jurors don't have to be convinced beyond a reasonable doubt. It means more certainty than not, having around 51% certainty. Clear and convincing evidence, a third legal threshold typically used in deportation, custody, or civil commitment cases, having around 75% certainty.
Thank you, jurors, for taking the time today to participate in your civic duty as jurors. We hope this video helped you cover some issues that you might encounter and address the solutions.
Signing off, this is Oscar.
And Juliet. Thank you.